The vast majority of the administrative state that you praise and think, well, we need to have it, is just wealth destroying, rent seeking by industries that capture the political process, right? So why would we want to build a constitutional theory around validating the administration state? Marshall did say the Constitution is designed to be adapted to ages to come. That sounds to me like translation, right? If things change, right, in some way that requires a different application of the principle enshrined in a document, as Marshall said in Marbury, Congress can, by legislation, adopt a certain result. That's like regulating interstate commerce when something wasn't commerce in 1790. I don't think that language necessarily means that Marshall is not an originalist. And the fact that a judge who at one point articulates a great theory for originalism then departs for it in certain cases doesn't mean we therefore throw out the rule book in the same way that we don't throw out the rule book because a referee gets a call wrong. Right? Even if the referee does so intentionally, we don't say, okay, therefore all referees should ignore the rules. But we still haven't articulated an alternative theory, by the way. Don't wait for that. Got 5 minutes for the alternative theory. I agree with everything you said about the Privileged Immunities Clause. Seems right to me. That's fine. I don't think abortion is a privilege or immunity of citizenship. I don't, so even if we agree that the Privileged Immunities Clause is a font of substantive rights, right, that the slaughterhouse case is wrong, I don't think that a lot of the rights that people want to read into that necessarily are the sort of rights that the ratifiers have in mind when they adopt the Privileged Immunities Clause. In terms of the executive banning speech, that would exceed the scope of the executive power for the very reason you described. So you wouldn't need to put in the First Amendment a limitation on the executive power.
Okay, question over here.
Sure. Thanks. Professor Klarman, is this on?
Just shout it out.
No, we can hear you.
Okay. That's good. Yeah, I'll shout it. This might give you a chance to respond
Yeah,
to what you just said in part. But you said that perhaps the best argument against originalism is that originalists themselves aren't consistent to the theory. Isn't it, just by being a theory, an ideal in a sense, though? I mean, I'm Catholic, I'm not a perfect Catholic. What person holds perfectly to their ideals? And is that really a sufficient reason to discard any theory or idea?
Yeah, well, that's a good point. I think that Scalia and Thomas depart from originalism, not occasionally, but on a wide variety of issues where they don't like the outcomes that originalism would lead to. Alan's question is, what's my alternative theory? I'm deeply ambivalent about what the best way to interpret the Constitution is. I'm pretty confident that trying to figure out what James Madison thought in that vastly disparate world he lived in is not the best way, in the same way that I'm pretty sure if you want to solve problems of modern science or modern medicine, we think it was very peculiar to ask, well, what did people 200 years ago think? We probably figure that we've made sufficient strides, advances, that we may know more about these things than they did 200 years ago. My ambivalence is, in the debate between, I said this when I was talking to some students at lunch, in the debate between Scalia and Breyer, for example, in McDonald or when they take their dog and pony show on the road, Scalia says, I believe in originalism, I believe that judges ought to be bound by something hard, and Breyer says, I believe in active liberty, I believe in evolving social mores, and Scalia just makes fun of him when Breyer says that's something different from judges just making it up. I agree with Scalia. I think what Justice Breyer is describing at the end of the day is obfuscatory rhetoric that will justify judges saying whether they think abortion is important or same-sex marriage is right. So I agree with that. My problem is I don't think originalism as practice is very different from that. I'm pretty sure originalism, if it were seriously practiced as we're bound by what they wanted 200 years ago, is really unattractive. I'd actually prefer what Justice Breyer thinks to what James Madison thinks, just on the assumption that Breyer lives in the same moment as I do, he's part of the same culture, and therefore he's likely to have more similar views about whether we ought to hold African Americans as slaves or whether we ought to oppress people because of their sexual orientation. So I'm pretty sure I'm going to be more supportive of that. But at the end of the day, I think the conflict is going to be, do you believe in majoritarianism? Do you think we ought to just have people vote? Or are you comfortable with the judges, in some sense, reading their own preferences into the Constitution? And again, I'm pretty ambivalent about this. Democracy sounds pretty good as contrasted with the values of the social and cultural elite. until you think of all the awful things that Democratic majorities do. So I don't really want Nazis voting on whether to gas Jews, and I don't really want Americans voting on whether to enslave African Americans. I don't want the country voting on whether to establish a Christian religion. And I don't want Californians voting on whether to have same-sex marriage, just like I didn't want Mississippians voting 55 years ago on whether to segregate blacks. So I'm pretty confident that everybody in this room is not an absolute proponent of let's turn it over to Democratic majorities. And if you're not taking that position, I think you're stuck with judicial. If you're buying into judicial review, I think you're stuck with judges exercising some discretion. So Alan and I actually have a fair amount of agreement on this. I'm with Scalia when he makes fun of Breyer. I think he is just coming up with convoluted ways of saying, I think gay marriage is really important. But I think it's really important too, and I don't see why Democratic majorities should get to vote on that. What's so great about democracy if it leads to those sorts of practices?
Only about 4 people.
Right. There's someone on my
it's not working. I just wanted to go back to looking at a number of statements regarding the continuity with the past, and that we cannot judge what we do today on the past. I look at the Declaration of Independence and the Constitution, and I'd like to question both of you with the same question. Are there not still some self-evident truths that are based on law above man?
I'm going to guess that Alan and I both agree that the answer is yes. There are some things that are right or wrong, and it doesn't depend on what a majority votes. But we both think that reasonable lawyers will disagree on most of those issues, and if you ask them to just decide, does the Constitution mandate that we respect fetuses, or does it mandate that we respect women's right to choose, you're basically just asking the judges to read their own values into the Constitution. I think Alan and I agree with that. I think we both agree there are transcendent truths, that it's not okay to enslave people just because a majority votes, and it's not okay to have a genocide just because a majority votes. I think we both agree with that. But I think we also both agree that if you ask judges just to figure out what these eternal truths are, they're going to disagree, because Scalia might think it's the right to keep and bear arms, and Breyer certainly doesn't. And Scalia might think it's that government doesn't get to take into account the race of its citizens in adopting affirmative action plans, whereas Breyer thinks it's the right of a woman to choose abortion. So they're just not going to agree, right? All these concepts that we can all agree to are at such a high level of abstraction that it camouflages our disagreements when we get down to very concrete iterations of those principles. Right? We all believe in equality, we all believe in liberty, but if you start figuring out whether we all agree about government redistribution of wealth, or whether we all agree about a woman's right to abortion, those abstract principles are not going to generate determinate answers. We're just going to disagree. We agree about that.
I think that's perfectly good. Something, yeah.
Question?
I was wondering if you guys could speak a little bit about the Fourth Amendment in light of changing technology, things like telephones and the internet, that because the Fourth Amendment is so very specific in the way that it's written, it lists, persons, houses, papers, and effects, and nothing else. How does that change an originalist interpretation of illegal searches and seizures?
Sure.
I mean, look, the Fourth Amendment, the overriding rule is reasonableness, right? The search has to be reasonable, right? And you laid out the search of what? I think that's very easy generally to apply in light of changed technology, right? Search of my person would include the search of my BlackBerry, maybe, that I'm carrying, right? So it's an effect, it's property, right? Just like my basket, if it were 1791, or whatever I might carry, or a letter. Right, so I have an email to the dean instead of a letter to the dean, which I would have written in 1790, right, something like that. So, in my, I think the Fourth Amendment can be applied quite readily in light of changed circumstances and changed technology. Justice Scalia said this himself on the question of how long you can detain somebody, right? Maybe 100 years ago, we would let the police detain somebody for 72 hours without a hearing by a magistrate because it was hard to find a magistrate. Today, we have telephones and email and fax machines. It's much easier to contact the magistrate and say, look, judge, this is why we're holding this person, which is why Justice Scalia, right, to the chagrin of some of his other colleagues, said you can only hold somebody for 24 hours. while more moderate progressive justices, like Justice Souter and Justice O'Connor, were saying you can hold somebody for 48 hours. Right? Because Justice Scalia said times have changed, technology has changed. What may have been reasonable 100 years ago is no longer reasonable today. That's an example, sort of translation I was referring to earlier that Professor Klarman doesn't like. So I do think that originalism works just fine in that context.
It's not that I don't like it, it's that I think it's probably incoherent. And it's a very good question, and I think it illustrates how Scalia is probably not consistent. So his position on the Fourth Amendment and whether you can use this heat sensing technology to figure out if someone's probably growing marijuana in their home, he takes what Alan describes as the liberal position.